The UCC Business Development and Consulting Institute is a multifunctional business development organization and member of the Small Business Development Center Network, providing services to assist MSMEs in achieving their business objectives. Our business consulting services improve all facets of corporate operations. Our back office services, Value Edge and Legal Bloom, are designed to provide an effective suite of accounting and financial management solutions and assist businesses in formalizing their activities while conforming to the legal framework such as tax and labor requirements. Learn more about our services at www.bdci.co.
Hi, good afternoon, everyone. Good afternoon and welcome to today's labor law webinar. We are honored to have with us an esteemed speaker who brings over 25 years of experience in industrial relations, Mrs. Melissa Kalash-Manahan. Mrs. Kalash-Manahan joined the Ministry of Labor and Social Security in 1997, where she has dedicated her career to fostering positive workplace relations. Throughout her time in the ministry, she has worked in several capacities, most notably in industrial relations, earning a reputation for her professionalism, knowledge, and approachability. She holds a Bachelor's of Science in Psychology with credits in Human Resource Development from the University of the West Indies, along with a postgraduate certificate in general management. Mrs. Kalash-Manahan is preparing to also pursue a postgraduate qualification in training and education to further enhance her expertise. Beyond her impressive career, she is a local preacher on trial at the Coke Methodist Memorial Church and an enthusiastic motorsport fan. In service to her community, she has been a dedicated member of the Optimist Club of Kingston Central since 2011, currently serving as its immediate past president. We're excited to have Mrs. Kalash-Manahan with us today as she shares her insights on evolving the evolving landscape, of labor laws and industrial relations. Please join me in welcoming Mrs. Melissa Kalash-Manahan.
Thank you, Ms. Minzy, for that introduction. And I want to thank UCC for the opportunity to share the information that I have prepared to share today. So let me just get right into it and share my screen. I trust that you're seeing my screen.
Yes, we are.
Oh, good. So, as you heard before, I'm from the Industrial Relations Department, and the Industrial Relations Department within the Ministry of Labor and Social Security is responsible for the promotion and maintenance of industrial harmony in Jamaica. So today, the labor laws are quite vast, so I have tried to concise the information as best as I could. So I'll be sharing with you some aspects of the Employment Termination and Redundancy Payments Act of 1974, the Holidays with Pay Order of 1973, Maternity Leave Act of 1979, the National Minimum Wage and its provisions. We will also look at briefly on flexi work arrangements and the Labor Relations and Industrial Disputes Act. I will introduce the Labor Code, which is a very important tool for organizations to have, and I'll look at some disciplinary procedure and how to go about and what due process is. So the Employment Termination and Redundancy Payments Act of 1974 was enacted in Prior to that was the Masters and Servants Act of 1842. However, in 1974, it was considered that the Masters and Servants Act was outdated and not in keeping with modern thinking. So it was therefore repealed and replaced. And I'm sure many of you on the platform is saying that you think it's time for this one to be further amended or repealed. So prerequisites for notice under this act: an employer is required to give a minimum period of notice once a worker has been employed continuously for 4 weeks or more, and Section 3.1 speaks to that. Or if it is that this notice for, you might say 4 weeks, but if there is a provision for probation, then I'll get into that. An employee is also required to, by law, to give notice once employed for the same period. So the provisions that an employer would have to make under this Act, Section 3.1, it represents the minimum notice to be given by an employer to terminate the employment contract. So once a worker has been employed for a month to 4 years, the employer is required to give 2 weeks notice. If the worker has been employed for 5 to 9 years, then they're required to get 4 weeks notice or payment in lieu of notice. I have to add that. So it's notice or payment in lieu of notice. 10 to 14 years is 6 weeks notice. 15 to 19 years is 8 weeks notice. And once you've been employed for 20 years or over, you're required to receive 12 weeks notice or payment in lieu of the notice. So who knows, maybe we will have some further amendments to this act, seeing that the Gen Zs don't want to be employed for longer than 2 or 3 years. Also, the statutory notice requirement by employees, and Section 3.2 speaks to that, is that this notice is to be given in writing unless it's given in the presence of a credible witness. And a credible witness is deemed to be a justice of the peace, superintendent of police, medical doctor, minister of religion, and so on. And an employee is also required to give 2 weeks notice. An employee is always only required to give 2 weeks notice to an employer to terminate the contract of employment, regardless of the length of service. So that is a drawback, because previously I'd shown the different years and the number of notice that an employer would be required to give. So during a period designated as probation in the employment contract, either party can terminate the contract without notice, or where this probationary period is greater than 90 days in duration during the first 90 days, Section 3.4. So what that simply means is that if you're within your probationary period, that is mandated by law, which is 3 months. So if you're working somewhere for 2 months as a worker and you do not think that is the right fit for you, then you can leave without giving notice. That is what this is saying. Likewise, if an employer has a worker within the place of work, say less than the 3 months, probably 2 months and some days, and you don't think that they would fit into the environment, then you can ask them to leave without giving them notice. Now we get on to redundancy. So the prerequisite for redundancy payments is that employees who have been employed continuously for 2 years, which is 104 weeks, and are dismissed because of a redundancy situation may receive compensation as stipulated under Section 5.1. So it's important for us to note that it's the job or the position that is made redundant and not the person. Dismissal by way of redundancy. It's important to note that it must be established that the worker was actually dismissed before any issue of entitlement to a redundancy payment can arise. So that has to be established. An employee will not be considered dismissed for the purposes of redundancy if his or her contract of employment is renewed, or he or she is re-engaged by the same employer under a new employment contract. If the renewed or new contract does not differ from the previous contract as to the capacity and place and the other terms and conditions of the contract. However, such renewal or re-engagement must take effect immediately on the ending of his or her employment under the provisions that is made under Section 5(6)(a) of the Act. In the case where the capacity and place will not remain the same, the offer to renew or re-engage the worker must be made in writing before the end of the employment under the previous contract. The renewed or new contract must take effect immediately on the ending of the previous employment or after a period not more than 2 weeks after the ending of the same contract. And Section 5(6)(b) is what speaks to that. Now, the prerequisites for redundancy payment, Section 5(2) of the Act sets out what amounts to a redundancy situation. Now, the fact that the employer has ceased or intends to cease or to carry out business for the purposes which the employee was employed by him or her, or has ceased to or intends to carry on the business in the place where the employee was so employed. And this is referred to as a cessation of business qualification. Simply put, the place locked down. The business is no more. The fact that he or she has suffered personal injury, which was caused by an accident arising out of and in the course of his or her employment, or has developed any disease prescribed under the Act, being a disease due to the nature of his or her employment. And this is loosely referred to as medical redundancy, but it is redundancy to qualify for redundancy. So if you're working and you lose a limb, which will prevent you from working as you would normally work, and the law sets out the prescribed chemicals that you would have to be exposed to in order to qualify for payment of redundancy. And the redundancy calculation, let me just input that, is 2 weeks out of each year for the first 10 years and 3 weeks for each year for the remaining years. So the worker must be provided with a written statement of how the payment is calculated under Section 9. So if your position is being made redundant, the onus is on your employer to give you a written statement as to how your payment is being calculated in terms of notice, the redundancy calculation. If you had unused vacation, that should be included in that written statement. If the employer does not provide, he or she is liable under criminal conviction to pay a fine not exceeding $250,000 or 3 months imprisonment. Let me interject by saying that these fines are currently being revised. So hopefully we would have some information as to what the new cost would be. So if an employee has not received this statement, he or she may request in writing from the employer. And if the employer fails to produce it within a week, the same employer may, upon summary conviction, will be fined, because the worker will provide the evidence that I did seek information as to how my payments would be calculated. So if the employer does not respond, then that's a breach. Payment of the redundancy must be at the current normal rate of pay. So to have a valid claim for redundancy payment, the worker must, within 6 months of the date of the redundancy situation occurring, have given the employer a written claim for the sums due, have already begun a claim in court, because you can go to court, you don't necessarily have to come to the ministry, have agreed for the payments with the employer. So you could So if you're working and your employer has informed you, or if you as an employer have informed your workers that a redundancy situation is in place and their position is affected, then, and you have not produced a statement to them, they can write to you with the claims that are due, but they have to do that within 6 months. This is what this is saying. You have to make a claim for your redundancy if within 6 months. Now we are on to layoff. And I'm using a definition from the book Industrial Relations, A to Z of Industrial Relations in the Caribbean Workplace by Philip and Hussey, page 93. So this is a temporary measure undertaken to reduce the workforce owing to cutback in production, machinery breakdown, or temporary closure of operations. Workers are laid off without pay during the period of layoff. So this provision is in the same legislation, the Employment Termination and Redundancy Payments Act. So Section 5A1 states that where an employee has been laid off without pay for in excess of 120 days, the employee may, by notice in writing, we can't stress that, to the employer elect to be regarded as being dismissed by reason of redundancy. The effective date of dismissal must not be less than 14 days and not more than 60 days after the date of the notice itself. And if the employee is then offered alternative employment in accordance with Section 6.3 and 6.4, no redundancy is payable. So if you have been laid off, 120 days has expired and you have written to your employer electing that the position be regarded as being made redundant, your employer has 14 days in which to respond to you. And if they respond to you by way of stating that there's alternative employment, you would not be due redundancy pay. Section 5A2B, a person may still be considered to be laid off without pay, notwithstanding the fact that during the period of layoff, he or she receives more pay or is engaged to work for limited times only. We had a lot of this happening during COVID, where in order to sustain some of the workers, their days were reduced. So if you were accustomed to be working for 5 days, your days might have been cut to 3 or 2. That still would be qualified as a period of layoff, because when you were employed, your contract of employment stated the days that you were required to work and what remuneration you would have received. So if you're receiving less during a particular period, then it will be treated just as if you were laid off. And it's important to note that records should be kept by employers, where it is required that the employer must keep records for each employee, and failure to do so leaves them liable to a maximum fine of $250 or 3 months, and all the fines are currently being revised. And now I'll move on to the Holidays with Pay Act and Order of 1973. So the Holidays with Pay Order regulates the granting of both vacation leave with pay and sick leave with pay. If in each qualifying year, the employee has worked for 220 days or more, 220 days is approximately 10 months, he or she is entitled to vacation leave with pay of 2 normal working weeks. And this is for persons who have been employed for a year up to 9 years. If you've been employed for 10 years or over, you earn 3 normal working weeks each year. A worker who has worked 110 days, which works out to approximately 5 months or more, but less than the 220 days, in any qualifying year of employment, earns 1 day vacation leave for every 22 days that he or she has worked. So that's how you earn your vacation. You work You earn your vacation based on days work, so you earn 1 day for every 22 days that you have. Vacation leave entitlement does not include rest days and general public holidays. Vacation leave should consist of consecutive working days on which the employee would normally be required to work. And there is a calculation for vacation leave if the person only earns commission. There are some persons, whenever they work, they do not earn a basic pay, they only earn commission paid work. So the calculation for that is 1/65 times the last 13 weeks, the sum of the last 13 weeks, and that will be equal to 1 day's pay. And I must make a point here in terms of vacation days. I know there are some persons, some organizations that practice that if an individual is absent for a day, they choose to take it from the vacation leave. That should not happen. Vacation leave should be for vacation leave purposes only. Now we're on to sick leave. Absence from work due to illness may be either certified by a medical doctor or uncertified. And let me just clarify what the uncertified is. So you can, if you're not well at home and you call in for day 1, you wake up next day, you're still not so well, you call in. And on day 3, you call in again. But if it is that day 4 comes and you're still not feeling well, it would be best to go to the doctor, because you would have to produce a doctor's certificate if you're going to be absent from work due to illness for more than 3 days. If a worker falls ill during the first 12 months of his or her employment and has completed 110 days, he or she is eligible for paid sick leave on the basis of the 1 day for every 22 days worked. And now we're on to the Maternity Leave Act, Maternity Leave Act of 1979. So, qualify for maternity leave with pay, the worker must be at least 18 years of age and has to be continuously employed for a minimum of 52 weeks by the employer as at the date of maternity. Should be working for a minimum of 18 hours per week and inform her employer in writing of her intended absence due to pregnancy and that she intends to return to work. At present, we do not have a legislation for paternity. I know that question is brewing. What we have is a policy, government has a policy, and there are organizations that do have a policy, a paternity leave policy in place, but it's not legislated as yet. Yes. So confinement, birth of a child or children, or the birth of a child or children, whether living or dead, after 28 weeks of pregnancy. So if you give birth to a child after 28 weeks, which is 7 months, you're qualified for maternity leave with pay. Even if the child did not survive, you're still entitled to the maternity leave, which is 12 weeks in total, 8 weeks with pay and 4 weeks without pay. That's the minimum that the law requires. There are organizations that grant you all 12 weeks with pay, and there's no challenge with that. A qualified worker who has been granted maternity leave shall be allowed to return to work under the terms and conditions of her original contract of employment. However, the Act stipulates that the worker should notify the employer at least 3 weeks before she resumes. For those persons who might have workers within their household settings, once they're contributing to NIS, the NIS office is who is responsible for paying maternity benefits. And now we're on to the Minimum Wage Act that was enacted in 1938, but we have had amendments. So a worker to whom minimum wage rates are applicable and who has been paid wages less than these rates is entitled to recover by judicial or legal proceedings the amount by which he or she has been underpaid. So the current national minimum wage that was amended on the 1st of June 2024 for 40 hours worked is $15,000. So the single time rate is $3.75 per hour. If the person works over 8 hours per day in a given day or 40 hours per week, the time and a half rate is $562.50. And if they work on a public holiday or if they work 7 days a week, the 7th day is calculated at double time, which is $7.50 per hour. And for those persons who are not minimum wage earners and they do work on a flexi work arrangement, the employment flexi work arrangement miscellaneous provision bill to 2014, pardon me, was tabled and debated by both houses of parliament between September and November 2014. The act came into effect on November 25, 2014, and this process resulted in the establishment of a legal framework for the implementation of flexi work arrangements. This means that the traditional Monday to Friday, 9 a.m. to 5 p.m., 8 hours per day, and the elements thereof can be negotiated by the worker. And we have seen where this has been working in some areas. So as a result of some laws have been amended, so namely the holidays with pay order. The holiday with pay order would only look at 5 days. Now, if you're under a flexi work week arrangement, then all the days would be taken into consideration. So you might be working, your week might start not on a Monday, but start on another day. So that's how that was. The Labor Relations and Industrial Disputes Act was amended. Shops and Offices Act, Regulation, Towns and Communities Act. When you had opening and closing hours, there were certain days that businesses were not supposed to be open, but now we have the Women Employment Act. That act stipulated that women could not work beyond 10 p.m. daily. So those acts were amended or some were repealed. And now we move on to grievance and disciplinary procedures. Whenever a dispute is to be reported to the ministry, the aggrieved worker, his or her representative or the employer is required to submit a letter formally referring the dispute to the permanent secretary. Pardon me. The dispute is then assessed and a pre-conciliation meeting or a conciliation meeting is scheduled. The disputing parties then meet at the Ministry of Labor and attempt to settle the matter. This act was intended to provide a third-party settlement of disputes, generally and not only those related to the essential service, and that's the Labor Relations and Industrial Disputes Act of 1975. The act also created a framework for voluntary conciliation for the stakeholders, workers, management, and or their representatives. The act created a permanent industrial disputes tribunal, the IDT, to handle all disputes instead of an ad hoc appointment for each dispute. And the IDT consists of the chairman, one member appointed by the minister from a panel supplied to him or her by organizations representing employers, which is the Jamaica Employers Federation, and a member appointed by the minister from a panel supplied to him or her by organizations representing workers, and that is the Jamaica Confederation of Trade Unions. The Labor Relations Code purpose, and it's this book here, the Labor Relations Code, was established in accordance with the provisions of Section 3 of the Labor Relations and Industrial Disputes Act. Its purpose is to set out guidelines that, in the opinion of the Minister of Labor, will be helpful for the purpose of promoting good labor relations, having regard for the following: the principle of developing and maintaining orderly procedures in industry for the peaceful and expeditious settlements of disputes, the principle of developing and maintaining good personal management techniques designed to secure effective cooperation between stakeholders. It also recognizes the dynamic nature of industrial relations and interprets it in its wildest sense, human relations and society in general. So recognition is given to management in the exercise of its function and the effective use of its human and non-human resources. It recognizes the inevitability of conflict and establishes a process for pursuable options. The code applies to all employees, workers, and their representative organization, and it complements the Labor Relations and Industrial Disputes Act. An infringement does not render anyone liable to legal proceedings. However, its provisions may be relevant in deciding any question before a tribunal or board. So we'll go into the disciplinary procedures now. So this is that was just to tell you the tools that are used. Any action, usually against an employee, arising out of a breach of rules, regulations, or acceptable standards of conduct or behavior, every manager has the right to exercise disciplinary action without the inevitable objection of a union. In accordance with the Labor Relations and Industrial Disputes Act amendment in March 2010, non-unionized workers may refer disputes that involved physical conditions in which any such worker is required to work, termination or suspension of the employment, any matter affecting the rights and duties of employers and employees. So Section 22 of this code, a company's disciplinary procedure should reflect the following steps as outlined in Section 22 in order to prevent unfair dismissals. So that is why it's often suggested when persons engage the ministry that they use the labor code as a guide in crafting your own disciplinary procedures in handling matters to prevent unfair dismissals. So in your disciplinary procedures, you should specify who has the authority to take various forms of disciplinary actions and ensure that supervisors do not have the power to dismiss without reference to more senior management. And the matter giving rise to the disciplinary situation must be clearly specified and communicated in writing to the relevant parties. You should give the worker the opportunity to state their case and offer a defense or an explanation, and the right to be accompanied by a representative. You need to give the worker the right to appeal wherever practicable, to a level of management not previously involved. The process is simply, you need to just write the worker about whatever the breach is, the charge, misconduct, and you provide the evidence. So if it is that a complaint was filed against an action, you need to ask for a report. And if it is you're going to ask the worker, invite the worker to a disciplinary hearing, you need to provide them with the evidence of that report. And you also need to advise them that they need to select a representative of their choice, not one you supply to them, their choice. And of course, you state the date, the time, and the venue of the hearing, and the right to appeal. So when you hear that you breach natural justice during a hearing, sometimes when matters are referred to the ministry, they always say that they are claiming that the company breached natural justice. So you have to ensure that the rules of natural justice are observed. No one shall be judged in his own cause. So no longer you hear something or you suspect something and you say that person is out. You have to have a disciplinary hearing. And because everyone is entitled to a hearing. The evidence used against the worker concerned must be provided to such a worker before the hearing. I'm overemphasizing that. And the person who accused the worker cannot be a part of the final decision. And you have to ensure that minutes are taken during the hearing, and the worker must have a fair hearing. Everything should be above board. Thank you for listening. Are there any questions?
Thank you so much, Mrs. Kalash Manahan. I have to take my time, you know. I am sure that all the attendees would have appreciated that, and on behalf of the UCC's BDCI, would like to extend our heartfelt thanks, right, for sharing your invaluable insights on the labor laws and industrial relations, right? It would have really enriched the session, and we really appreciate your time and dedication. It's been a privilege having you today, right? There are some questions, so I'll just go through those right now. So the
Sure.
first question was, I'm not sure what this person was trying to say. Shelley and Evan said 2 or 3 years. I'm not sure. It wasn't very detailed.
Probably they need
However,
to type it again in the chat to see.
they can raise their hand and try to expound. I'll allow them to
Okay,
speak.
good. That would be good.
In the meantime,
Another one?
yes, Tamara Blackburn said,
Mhm.
is there a statute of limitation on a false redundancy, i.e., the employee was advised that the position was being made redundant, but shortly after the position was filled by a new employee? Same job description and title. Can it be contested? And if so, is
Yes.
there a period that it must be done within?
Yes, that can be challenged through the Industrial Relations Department, but they have a year in which, so it has to be done within the year, within the first 12 months to challenge that.
Okay, thank you. I hope that answered your question. So, this is anonymous. This person is anonymous. Good day. Can the employment contract outweigh the law as it relates to the notice period? That is, where the contract requires a reduced period than what is prescribed by law.
Well, you can't contract yourself out of law. So if the law says you're to get 2 and your contract is saying you're to get 1, that's a no-no. You would have to bring that to the attention of the Ministry of Labor for that matter to be addressed.
Awesome. All right. A Gario Banks, right, said some employers, namely BPOs, offer a contract break for up to 6 weeks in between contractual agreements. I'm thinking that that's a statement.
Well,
not more of a question.
fixed term contracts, that's how they operate. When you have you have a start date and you have an end date, and then you'll have a break, at least 3 weeks break. So they would giving them time to decide, to assess, I guess, either to get a new bunch of persons, or if you had performed good, they might re-engage you again. So that is what that's how the fixed term contracts normally operate.
Awesome. Tamara Blackburn said, please expound on NIS paying maternity leave.
Okay, so if you have your household worker, you get a card from the NIS office, and you would purchase stamps at the post office. And once that card is completed, you will take it in, I think it's the end of March, you get a receipt. So each time you fill out the card, then you get a receipt. So if it is that you have somebody in your employ who happens to get pregnant, they would take the receipts to the NIA office, or they can take their NIS card because the information would have been on a system. So once they see that the person has contributing or their contributions that are coming in for the worker, then they would be paid for the maternity leave. The only thing is that you would get it at the basic rate, normally at the national minimum wage. That's how it will be paid.
Right, thank you.
I see there's a
Alright,
hand raised.
right.
Right. Go ahead.
You can go ahead and speak, Opal.
Hello, yes, you hearing me now?
Yes, I'm hearing
All
you.
right, good. So I was just trying to find out if that is the responsibility of the worker or the person who hires the worker.
Okay.
I'm referring to the maternity leave with the
You mean contributing to NIS?
yes.
Well, once a person is employed, you know that it's shared. It's shared, but you know, custom and practice, the employer normally just do that for the worker, because it's not a lot.
Mhm.
But the principle is that it will be shared half by the worker and half by the employer.
Oh, okay.
Right.
Thank you so much.
You're welcome.
Awesome. So back to the questions. Howard Kalash asked, are men eligible for maternity leave in order to support their spouse?
I didn't, could you repeat that question?
Are men eligible for maternity leave in order to support their spouse?
Okay, so as I had said before, we do not have a legislation for paternity leave, but there are policies across industry. Well, recently the government has implemented a paternity leave policy. I know there are organizations such as Flow that have a paternity leave policy, and there are others too. Can't remember all of them, but there's just a policy as it present. We must appreciate that Jamaica has a very unique culture. So we have to, you know, in crafting such a legislation for men, I guess the lawmakers have to be very careful in crafting that legislation. But hopefully we'll have a policy, a legislation for paternity leave in the near future.
Hopefully. All right. So Stacey and Jones is saying, is there a difference for persons providing services as independent contracts to an agency?
If there is a difference, if you're independent, that means you're working for yourself. So you're not classified as a worker under the law. So you will be working for yourself. So I don't know if anything else is unique about that situation, she probably would want to expound. I don't know. But if the person is not governed by the organization they have a contract with, the organization does not determine when they work, does not discipline them, that sort of thing. So those are the tests that are used to determine an independent contractor from a worker. Because I'm sure persons might have heard it's being loosely said that the industrial security guards were independent contractors, which clearly that was not so, because they're provided with uniforms, the tools for their work, and they were assigned duties. They were told when to come to work, when not to come to work, that sort of thing. So once there's control by the company, then you could not be an independent contractor. But once there's no control, then clearly you work for yourself. You're not a worker under the law.
Much appreciated. I hope that answered the question.
I hope so too.
Karen, I'm not sure about the hyphenated name, but Karen Brown. Following up on your earlier answer, what if the contract asks for a 3-month notice and the law says 2 weeks? In other words, more notice is required than the law states.
Okay, so that will be an agreement. I should have mentioned that there are some organizations based on how they operate would want to give you, would want to put in place a longer period for notice. The most I've heard about is 4 weeks, but there have been some that says 6 weeks, I guess, due to the nature of the job, and one could understand it. So if it is that you have agreed to that, then it is best to honor that agreement. Because I'm sure this would have been communicated upon interviews and all of that. So you would have made a decision, no, this is not where I want to be. So, but if you agree to that, then you'd have to honor the agreement.
Right. So basically, once you had signed something saying that you agreed to that, you'd have to go ahead and abide to it.
Right. It's the only way the law would have a difficulty if it was less. If it's less than what because whatever the law prescribes is just the minimum. Because even for the redundancy situation, it's 2 weeks out of each year. I have seen a document recently where this organization has been generous. They actually say persons working from 1 to 4 years get 2 weeks, and 5 to 9 get 6 weeks each year. So it depends. The law is just giving you the basic. If you can give more, you give more.
Right. Awesome.
Right.
Thank you. Clans. This is okay. So Clans is asking, is there an ETRPA booklet?
There's
And
the
where
Jamaican, there's a
can I
Jamaican
get it?
labor law.
Okay.
There's a Jamaican labor law, and it's a huge book that has a lot of laws, including all of that, those that I have mentioned. The Jamaica Printing Service is where you would purchase that, or there's some online that you could look at. On our website, we would put the laws that are relevant to us on our website under the Industrial Relations Services. If you access our website, they're posted there.
Michelle, you can go ahead and speak.
Hi, good day. I was just looking at the question and answer section, and I saw a question about somebody being made redundant or not being paid on time. I didn't hear an answer for that, so that's where I went. I wanted
All right, so
the host
okay,
to
thank
speak with.
you.
All
Yeah.
right.
But I'm going in order of how they came in.
Oh, I'm sorry. I just was looking at the question and answer in my little thing here on my phone.
You're curious about that one, eh?
Yes.
All right, then. I'm just gonna continue with the questions.
Okay.
All right. So Anonymous asked again, what records are required to be kept by each employee?
The employer.
No, they said what records are required to be kept by each employee. I'm guessing for each employee by the employer, but they didn't specify that.
Right. So of course, everything relevant to your employment. So if there is an application form, if there is a contract of service document, and you should also have a copy of that contract that you sign. Any agreement that you sign, you should also ask for a copy and keep it as well. There are wage documents. The employer should also have a copy of the labor laws, because it's a breach. Because once you're operating a business, you should ensure that you're maintaining the law. So very soon we're going to have a robust general compliance service where we will have inspectors going out and doing routine inspections. Back in the days, we used to do it, but as the volume of work has increased, our priorities have always been shifting and all of that, but yes. So we're going to have a general compliance inspectorate who would be going out. So it's important. So if there are any employers on the platform, I ensure you just put your house in order.
All right, then we have 11 more questions to go, and we're gonna
That's
try
all
to go
right.
through
That's
them
fine.
quickly.
That's fine.
So if an employee is being terminated for egregious behavior, act, theft on premises / misconduct, Are we
Mhm.
still required to pay them the minimum notice payment?
You're gonna have to have a disciplinary hearing, you know. That's the first thing I must point out. So, because we have to look at the circumstances. Why was the worker behaving that way? What led to that and all of that? I can't give a definite saying, no, they're not entitled to it. It has to be ventilated in a disciplinary hearing, and then based on the evidence presented, then it would be determined whether notice is required, yes or no. Before 2010, I could tell you, said no, and let them challenge it in court, but I can't say that on this platform right now. Since 2010, where persons do have a right to challenge any action against them.
All right,
Shoshana Thompson's hand is raised.
I'm gonna give her permission to speak.
Right. Shanna Thompson, I'm so sorry, Shanna.
Shauna Thompson, you had your hand up. You can go ahead and speak.
Thank you very much. This has been very, very helpful. But you were right. It was by employer. You had mentioned a note on here that all employers need to make sure that we keep records. Is there a way that we can know exactly which records we need to make sure that we keep of each employee?
And as I was saying, all records were relevant to their employment. So if when they made an application, that application form should be in a file. So you keep a file on each of your workers. If you gave them a contract of service, you need to have a copy of that on their file. Everything, when they go off on vacation leave, those documents should be there. Maternity leave, anything relevant to the employment should be in, you should have a file on that worker.
Thank you.
Right, and the wage records too, very important, because those are checked as well.
Was your question answered, Michelle?
No, she's still waiting. I don't think you get to that question yet.
No, I'm speaking of, okay, all right. So if you were made redundant, it's anonymous again, if you're made redundant and the employer advise you that they will not be able to pay the full amount at one time, an agreement was made to pay over 3 months and a year has passed and the full amount is still not received, what is my recourse?
Yeah, wow. Remember I said that you have 6 months in which to claim. So if it is, and let me just say this, if it is that, because the law says you have 6 months in which to make a claim. So 6 months, whether to come to the ministry, go to court. So if you had an agreement and you see that it is not being honored, it's best to act. So you could come to the ministry, even if you had an agreement, and say, I'm filing a complaint, because you would have started to the process. You file a complaint, you come speak to a labor officer, and they will take a formal complaint and you sign off on it. And then, because I would want to know if this agreement was documented and was it witnessed, all of that, because I'm not getting that impression that it was, because if it was, they would have to honor it if it was witnessed and if it was documented, because that is evidence. So if the person can put it in chat, was it documented or it was just word of mouth?
All right. Another question. So paid vacation rule. So paid vacation rollover, are there any laws around that, or is that at an employee's discretion?
What do they mean by vacation rollover? Is there a policy within the organization that grants vacations to be accumulated? Because the principle is when your vacation leave is due, then it should be paid. Or you can request your vacation, and vacation is for vacation. You're gonna need time off. So is there a policy in the organization that grants you the flexibility to accumulate over a period.
All right, thanks for that. A question again. My que All right, Michelle wants to speak. You can go ahead,
Chef
Michelle.
Francis, yes. Mhm.
I'm aware of a similar situation. That's why that one aroused my interest. Yes, my understanding it was put in writing.
Okay, and
And
at
it is
no point,
acknowledged and agreed.
and at no point the person tried to engage the ministry.
Um, um, uh, not after the agreement was written and acknowledged.
Well, they should have done that.
Oh, wow.
They should
Okay.
have done that. As I said, you have 6 months in which to make a claim. Because the agreement was that the payment will be made in installments.
Yes, yes. And the person started receiving payments though, but at some point there seemed to have stopped with not much communication thereafter.
Okay, is it less than $1 million or $1 million? You know?
It may be a little more over $1 million. It's over $1 million, I think. I'm not sure
Okay.
though.
Okay. Mm.
So in this case, it's still, what would you recommend? Go back to the employer or come to the ministry?
They could come to the ministry and we'll try and see how best we could assist. We speak to a
Okay.
legal officer.
Okay.
I notice that Mr. Eccleston hand is raised.
Hello, are you hearing me?
Yes, Mr. Eccleston.
I
You
was
want to
only
take
in.
you want to take that one?
No. I was only just saying. I, I, I'm so sorry. I personally believe this now is a matter of breach of contract,
Yes.
and I was very happy when you asked if it were under a million or over a million, because what I
Right.
would recommend from a legal perspective is that person go ahead and see a lawyer. Because to my mind, the fact that the parties now have a contractual arrangement in place, the 6 months limitation should no longer be an issue, in the sense that to my mind, they would have already sorted out what the payment would be prior to the ending of the 6 months period.
Right, and the payment has already started too.
And the payment, that's even more. There's some acknowledgement. There
Right.
is some act on the part of the employer by paying the money. So now, to my mind, it's now a question of not whether or not am I entitled under the relevant legislation, but a question of has there been a breach of contract? And if there's a breach of contract, as you rightly asked, if it's under $1 million, then certainly I would tell the person, go seek legal advice, or in relation to if it's under $1 million, go to Sutton Street and commence an action against, because at Sutton Street, you don't necessarily need a lawyer. There's nothing wrong in
No.
having one, but you can go on your own and they'll guide you. They'll
Right.
guide you. You
Yes,
can
that's
go
what
and
yes, but I didn't want to just offer that here, but I'm glad you keep.
I saw the reluctance, which is why I put up my hand immediately and I said,
I know, because if they came here, that's what I would have advised, but yes.
that's what I saw. And if it's
Right. Mhm.
speak to an attorney, and then the attorney would take the matter in the Supreme Court. And it now
Right.
becomes a matter of breach
Of
of contract to
contract.
enforce those rights which were put into writing. And you had asked the right questions. Was it signed? Was it witnessed? But the fact that payment was made is good evidence to demonstrate the
Say that
goodwill
it has.
on.
Right.
Yeah. Okay.
Thank you, Mr. Eccleston.
Anytime I thanks for allowing me that few seconds. Thanks.
All right, thank you as well. Another question is regarding vacation. For clarity, is it that at day 110 you would start counting
No.
at one worked the vacation earned, or is it at day 110 that we would have already earned 5 days? That is 110 divided by 22 equal 5 days.
That is correct. That is correct. So at day 110, you have already earned 5 days because you earn vacation based on these work. So you would have already started working and earning. But to qualify for vacation with pay, you have to complete the 110. That's what that means.
Right. Someone had asked if the recording will be available. Yes, it will be available on our YouTube as well as our website, bdci.co. Okay, so if you missed anything, you can always go ahead and check the recording out, all right? Another question is, what about a sexual dispute issue? How do we protect the accuser?
Sexual dispute?
Mm-hmm.
Under the new legislation, I think is the Ministry of Gender that deals with that. So you could engage them. I have to stick within my jurisdiction.
Right. All right, no problem. Please indicate if an employee can be suspended before the due process procedure.
You'd have to expound on that because I know that oftentimes when there are disciplinary, based on the nature of the breach, some companies would send persons off on administrative leave. It's not really a suspension. So I would love for the person to indicate if the person was being paid or not, or if or was it told to them that they're suspended.
All right.
Mhm.
I have a question for you. If it is that a employer was released of their duties while on maternal leave, what will happen in that sense? Is that right? What
They
would
can
they?
challenge that,
Right.
but the fines are being revised. The fines are being revised, and they can challenge that through the ministry.
Okay. So they would
Right.
have to come to you guys.
They will have to
stated.
come to the ministry, speak with a labor officer.
Okay.
Right.
All right. And they go from there.
And they take it from there.
Alrighty. Another question is, I remember Mrs. Kalash Manahan said vacation days should only be used for vacation only. So in the case that an employee has no sick days left, is the employer allowed to take the sick day out of their vacation days?
No, absolutely not.
Absolutely not.
Unless they agree, but I wouldn't encourage that at all. So I'm going to stick with absolutely not.
All right. For fixed term contracts, when is the ideal time to inform of a non-renewal?
That is not we don't deal with contracts like that.
Okay.
I just based on knowledge that I have, that's why I was expounding for persons to understand it better. But it is recommended that you could remind them at least 2 weeks before it expires. Michelle Francis has her hand raised.
All right, go ahead.
Question, say I have a farm and I have some people that works daily. In my opinion, they're now considered employees. You can agree or disagree. Then my question would be, who would be responsible for paying of their taxes? Income tax, NIS, NHT, all the what would you call it?
Statutories?
Yes, the statutories, yes.
Because who pays them?
The farm owner?
Right. So who owns? Yeah. So the employer is responsible for those.
Okay, so they are no employees. The fact that you're telling them to come to work and every day they have something to do.
Right.
Okay. Okay.
So you need to keep your wage documents. So if it is they fit within the threshold, you know what statutories need to be paid.
Mm-hmm.
Right.
And I just quickly ask this, if you have, say, for example, a construction company and you have a project and you just employ some people just for the day, it will be now their responsibility to pay their statutories, right?
I'd have to look at the contract.
Oh, but you don't have a contract per se. You just have them as a laborer, just come the day and just have this assignment done and
You
go.
need to have something in writing, the terms and conditions of how they are working.
Okay.
Yeah, you
Oh,
need to stipulate that because you don't want it to be left to what their interpretation is versus yours. And you're probably going to have to go to court to thrash that out. Because if it
Oh.
comes to the ministry, we would need some evidence as to how the terms and conditions are. And it's normally best to document it because, the onus is always on the person who employs the people.
Okay. So would you
Right.
have any sample document of those? Like for somebody that I have a project, for example, I do road paving.
Okay,
And
so
I have
what
a
I would
project and the person comes today and that's it. I don't see them
What I
again.
would suggest, to you is that you engage the services of a industrial relations attorney,
Mm-hmm.
and so that they can guide you as to what the best fit will be in your situation and to ensure that you're not breaching any laws at all.
Okay.
Right.
All
Oh,
right.
wow. Thank you.
So, all right. Thank you so much for the discussion. We'll be answering going forward only the questions in the Q&A as we are going over time. It's 2 to 3, right? I'm going to allow one last person that would have raised their hand to speak, and then after that, we're answering the questions, all right? Is that okay, Mrs. Manahan?
Sure,
All right.
fine.
So I'm going to allow Karen to speak, and you can go ahead.
Okay, thank you so much. I'm just following up. You said something, absolutely not, as it relates to if the employee goes over sick days, if the employer can then take it from vacation days. But what is the option available to the employer when they go over on the sick days?
Well, it's left to your discretion whether you're going to pay them or not.
Okay, so you can remove it from their salary versus
You're not removing it, you're just not paying them for the day.
for the days. Okay, but if they, okay, all right, fine. Okay, you didn't state what we could do. You just said we can't, and that was a concern. But thank you.
And yeah, I was attempting to say that if they work agrees, but I didn't want to entertain that because it's important for them to use their vacation for their vacation leave purposes.
Okay.
Right.
Okay. Thank you so much.
You're welcome.
As well as I know that this is a very informative session, right? The Minister of Labor and Social Security is there to call with all these questions, seeing that we can't fit it.
I can provide the ministry's WhatsApp
Right. So
number.
if you could just do that and share it right here, I would love that, seeing that we have so many hands today. I'm sorry we couldn't accommodate you all, okay? But I'll be asking, we have 8 more questions. If you want to stay and listen, no problem. I'm sorry we went over the time, okay?
No, that's all right. I understand. I'm accustomed to this, believe me.
All righty. All right, so if an employer pays its employees through bank transfer and email the payslips to employees, should the employer also print the payslips and attach it to the employees' files?
Well, that is evidence that they're paid, but I would prefer if they keep proper records, whether if they do it electronically but I would always encourage workers, if that is how your organization operates, then you have to keep your evidence that you're being paid. But as I said, we have a robust general inspectorate that is going to be out, so I'm sure this practice will be discontinued at some point in time.
All right, what's the best procedure for an employee to take whenever there's evidence of employee theft from the company?
I didn't get that, I'm sorry.
What's the best procedures for an employer to take whenever there's evidence of an employee theft from the company?
Employee theft? So if there's a criminal matter, who you report it to?
Police.
That's right.
All right, all right.
That's
With
taking care of the criminal aspect.
Okay.
In terms of the employment, then you'd have to hold a disciplinary hearing, clearly.
All right, awesome. Thank you. What's the best procedure? Okay. With respect to the recent ruling in the NHT versus Marksman Limited, where the security guards are no employees rather
They
than
were always
independent contract.
they were always employees, always workers.
They're
They were
asking,
always considered workers based on the law.
they're asking if they are now entitled to vacation leave payment in the back.
They were always entitled to vacation. I have been to court several times on that matter because, as I said, pre that landmark case, there were some security companies who insisted that these persons were independent contractors and refused to pay them vacation. So hence, whenever a complaint was filed at the ministry, we would need to despite our efforts, they did not engage us. So we would have to end up going before the courts. And of course, based on the law, because the law clearly defines who a worker is, and based on what was, they would always have to take the matters to court and they're paid. So they were always seen as workers based on how they have been working.
Okay, awesome.
I have placed the WhatsApp number in the chat.
Right. I sent it out.
Right.
All right. Next question. If an employee is terminated, how long can the employer take to pay all sums?
If they've been terminated, how long they
Right.
can take to pay?
All sums.
Well, it is the understanding, if you have decided to terminate my employment, then you would have made provisions to pay me what is due when I'm leaving.
Right. So
Hold on, I
basically,
think the last two numbers. Let me put it back in the chat. I think I got the last two numbers incorrect. Trying to multitask. I forget, so I can't multitask.
right. Guys, I see your hands. As soon as I finish the questions here in the Q&A, I will take the hands, all right? So please explain how vacation and sick leave are earned by someone who works. Not sure how that's go ahead, Mrs. Manahan.
Repeat that for me, please. I'm so sorry to be asking.
Please explain how vacation and sick leave are earned by someone who works.
Yeah, they're earned based on the days worked. The only difference is with sick leave is for sick leave purposes. So if you happen to be in good health for the year and you don't utilize your sick leave, you just don't get paid for sick leave. While with the vacation, if you work for the year, then you should be paid when it is due.
Alrighty, thank you so much. Just to confirm, if a person whose probationary period is 6 months resigns on the stroke of 6 months, is that former employee entitled to pay for 50% of their vacation allotment that they did not claim?
I beg your pardon? Somebody paying for what?
So just to confirm, if a person whose probationary period is 6 months resigns on the stroke of that 6 months, is a former employee entitled to pay 50% of their vacation allotment that they did not claim?
Well, if somebody resigns, yes, the 6 months, whatever they've earned, they should be paid. If they earn 6 days, they should be paid at 6 days.
Okay.
Right.
Sorry, who works only 3? I'm not sure who's to read this. I guess it's saying someone who works only 3 8-hour days or 2 8-hour days per week. Oh, I think Anonymous was answering what you were asking them to clarify something, read the days that they work. But I'm not sure how to put that together right now. I'm so sorry. What is the calculation for days payment and how much? What is the calculation for days payment and calculation to find out how much per day worked?
Well, if you if the person is a minimum wage earner, if you prorate the minimum wage, that I think that's just $3,000 per day right now.
So it's a set thing.
Well, unless the person negotiates for more, because persons do have the ability or the right to negotiate their wages. But they should not be getting less than $3,000 per day.
Okay.
Right.
If an employee is still in their probationary period, how is the best way to release them or let them go?
If they're in the probationary period, hopefully it's the 3 months that the person is referring to. You just tell them it's not working out and you don't need to give them any notice. Hopefully, providing it's within the 90 days, which is 3 months. If it's over that, then we'll have to look at the period that they were there.
Alrighty. Sorry, Anonymous said, sorry, the question was, please see follow-up question was how to earn the VL, that's vacation leave or sick leave.
1 day for every 22 days worked.
Okay. The person does not work a 40-hour week, they just work 2 to 3 days per week.
If
How
they
do
work
they
2
earn?
days, they don't earn. If they work 3 days or more, they earn.
All right.
So if you work 3 days or more, you earn your vacation, or you work at least 18 hours per week.
All right, those are the questions that I'm seeing here. Nika, do you still want to speak as well as Karen? I will unmute you guys and you can go ahead and speak one at a time.
Hi, good day.
Hi, good day.
All right, so the question that I'd asked was in regards to the calculation, because I know the last time I called, I got a calculation where you had 52. I don't remember exactly how you guys did it. I was trying to prorate the person's salary to find out how to pay them for their 2 weeks vacation because the person had resigned.
Okay,
But I don't
so
remember the calculation.
from you mentioned the 52, I know exactly what you're talking about. So is the annual salary divided by 52, that is what a week would look like.
Okay. And then from there to get the day.
You divide what you get at the answer that you get for the 52, you divide that by the days that they work.
Okay. So if they work 5 days a week or something like that.
So whatever you got when you divide the 52, you divide that by the 5, and then you get what a day's rate would look like.
All right. So let me say, for instance, somebody works for a month, for annual, you said, for an annual over 52.
Right. So they would work $1 million, right? And you divide that by the 52, you would get 19,000 for the week.
Something.
So
yeah.
Right. So when you divide that by the 5, you get
3,000
something.
Rate.
Right. That's the daily rate.
Okay. Okay. One more question. If someone
Are you muted, breaking up? I'm not hearing. You're
telling all the great things.
You're out.
Sorry, I got a call.
I didn't hear. Yeah.
So say for instance, someone comes in an interview, they give you all the information that you know, they tell you all the nice things. They get the job. However, on the job, they realize that they're not best fit for the position that they came into, because you're starting to see certain things. No, you see a particular other aspect of them where you can fit them into another position, and you want to close that contract to give them a new contract. What's the best way to do that? And can you have them have 2 different? So can I go for the first contract, you know, after your 3 months, I realize that this is not working out for you. You're not showing us what we want. But however, I see your skill set and I can put you in this. How do you do that?
You're sounding like a human resource person. The company that you work for, do they have an industrial relations attorney?
They do not. It's a small company and I'm the manager. So it's just we're trying
So
to learn as
it's
much.
best to engage one. Reason being is
Mhm.
that what you have just pointed out to me could very well become a dispute with the Ministry of Labor. No, that would
Okay.
not, right. So we can't advise you in regards to that. So that's why I am encouraging you to seek advice from an industrial relations attorney, or you have industrial relations consultants who offer the same services that
Mhm.
you can engage and let
But
them.
can I don't want to take my time and do this because I know we're late, but can I ask why though? Why is it to that point? Don't we have some sort of right to see where somebody is not in the right position to, or they don't have the right skill set, or they have not shown what we want in that position?
I would need to have more, and I think more information. I could not give a definitive answer at this point. Every situation is different. And
Okay.
I don't know what contract you're speaking to. I'm not looking at a document, so I can't say.
Got you.
Mhm.
All right.
All right.
I think that's it.
Okay.
Alrighty. And I'm not seeing any more hands.
Okay.
Thank you so much again, Mrs. Manahan. I
It
really,
was
really,
my
really
pleasure.
appreciate it. We appreciate it, the UCC's BDCI. And I appreciate the attendees for coming out and listening. I know for me it was an informative session, and I will definitely be calling the ministry. I hope they answer their phones or they answer the WhatsApp better. Which one do you prefer?
Well, the WhatsApp, they will respond.
Okay.
If you call our landlines, yes. Sometimes some of us give our CUGs.
Okay.
And right, so.
Noted. All right, then. If there aren't any more questions, right, this would be the end. 22 minutes after, but I'm sure it was worth it. Again, thank you all for coming out. If it is that you guys wish to have another session with Mrs. Manahan, I'm sure she would like to come back and go and give some more information. Because as she said in the beginning, there's a lot of laws that govern us as workers and the institution. So you can let me know and let me know if I should engage Mrs. Manahan once again. All right. I saw a hand go up, but it came down. So I'm okay. Michelle wants to say something, and Michelle is the last person, and then we're finished.
Mrs. Manahan mentioned her CUG, but I noticed she didn't give us a little something on it, because I understand where the moderator is going with these answering of numbers. Because can I tell you, oh my God, it's the hardest thing to get any of these places. I believe me.
382
Mm-hmm.
9601.
Repeat again. It just went out for a little.
382 9601.
96 you said? 9601.
Yes.
Thank you. 3829601. Thank you.
And it's also WhatsApp, because if you call and you don't get me, you could send me a message and I would respond
Appreciate that.
as soon as I'm able to, because I do many things as the pre-conciliation director. I am many places and I do many things.
Yeah, she's very busy. It was hard to get a hold of her. So please just be considerate when calling, all right? So you guys can visit their websites, right? That's where I found her. And again, thank you so much. This is the end of our session, right? I'll see you guys again soon, maybe at a different session. And thank you again. I don't know how more to say. I'm very grateful. Thank you, guys.
All right. It was my pleasure. And have a good afternoon, everyone. Be safe.
Thank you. I'm going to go to this on WhatsApp, you know.